In this lecture, we're going to discuss the final stage of the criminal justice process for offenders who have been incarcerated, and that is the parole stage, which also includes reintegration back into society. In particular, in this lecture, we're going to begin by discussing some of the key terms in the area of parole and release generally. I'll talk a bit about the philosophy of releasing offenders into the community after serving a sentence of custody in a federal provincial institution. Get into a little more detail on what is meant by conditional release or parole, which includes discussing the various types of paroles that's available to provincial and federal correctional inmates. Talk a bit about the issue of recidivism following release or reoffending by prisoners who've been released into the community. We'll then talk a bit about the National Parole Board, which is the federal agency responsible for parole in most provinces outside of Ontario and Quebec. And then we'll end with some criticisms of the philosophy of parole as well as parole boards. So a little more detail on conditional release or parole, and this slide provides a general overview. As mentioned, the whole idea of a conditional release or parole is that inmates are released before their sentence is completed. This decision is generally made by the parole board, but based on different kinds of release, it can also be made by correctional officials. There are different types of parole options, which we'll talk about in the next slide. Most inmates are eligible for full parole after 1/3 of their sentence is served, and many offenders in jail in federal and provincial prison are released after 1/3 of their sentence is served. Most inmates are eventually paroled either after 1/3 or 2/3 of their sentence. Key to the rehabilitation and reintegration philosophy is conditional release. Parole is seen as a very important aspect of reintegration, as we previously discussed. And also, we should make the distinction between parole and probation. Most people get this confused, although we have gone over probation in detail. Probation is a sentence, so probation is determined by a sentencing judge, and parole is determined by a correctional official or parole board after they've served part of their sentence within a correctional facility. So probation is basically where a sentence is served entirely within the community, and parole occurs only after someone has been incarcerated. So while both are served in the community, probation in itself is a sentence, while parole is early release after part of a sentence served in a correctional institution has been served. So a little more detail on conditional release or parole, and this slide provides a general overview. As mentioned, the whole idea of a conditional release or parole is that inmates are released before their sentence is completed. This decision is generally made by the parole board, but based on different kinds of release, it can also be made by correctional officials. There are different types of parole options, which we'll talk about in the next slide. Most inmates are eligible for full parole after 1/3 of their sentence is served, and many offenders in jail in federal and provincial prison are released after 1/3 of their sentence is served. Most inmates are eventually paroled either after 1/3 or 2/3 of their sentence. Key to the rehabilitation and reintegration philosophy is conditional release. Parole is seen as a very important aspect of reintegration, as we previously discussed. And also, we should make the distinction between parole and probation. Most people get this confused, although we have gone over probation in detail. Probation is a sentence, so probation is determined by a sentencing judge, and parole is determined by a correctional official or parole board after they've served part of their sentence within a correctional facility. So probation is basically where a sentence is served entirely within the community, and parole occurs only after someone has been incarcerated. So while both are served in the community, probation in itself is a sentence, while parole is early release after part of a sentence served in a correctional institution has been served. There are a number of conditional release options or parole options. In other words, there's different types of parole opportunities for inmates within a provincial or federal correctional institution. A temporary absence is granted so that offenders can receive medical treatment, renew contact with their family, perhaps undergo personal development or counseling or treatment in the community, even participate in community service work projects. Temporary absence decisions are usually made by correctional officials and can begin soon after admission into a correctional institution and can actually extend to the end of a sentence. So it can take place at any time during an inmate's sentence. Temporary absence may involve the use of electronic monitoring, and a temporary absence is usually the first type of release an offender may be granted. And a temporary absence may be escorted or may be unescorted. In other words, a correctional official or parole or probation official may have to escort the inmate while they're on their temporary absence, or in some cases the inmate can be released on a temporary absence unescorted. A temporary absence is usually just for a couple hours, maybe 3 or 4 hours, perhaps a day, but generally a temporary absence is quite short, measured in a few hours. A day parole, on the other hand, is just that. It's a parole for a full day, usually from morning until sunset. The purpose of a day parole is to prepare offenders for release on full parole or statutory release by allowing them to participate in community-based activities or as part of their overall reintegration process. Nonviolent offenders serving their first federal term are eligible for day parole either 6 months into their sentence or at the 1/6 point, whichever is longer. Now, most other federal offenders are eligible for day parole 6 months before their full parole eligibility date. So basically, day parole is a short period of release, usually a day in duration, and the whole point is to prepare the offender for full parole and in general for full integration back into society. Full parole is where the offender is released permanently. So unlike temporary absence day parole where they have to return to the correctional institution, a full parole is where the offender is released and serves the remainder of their sentence under supervision in the community. Inmates are eligible to apply for full parole after serving 1/3 of their sentence or 7 years, whichever is less. Full parole is granted by parole boards, while day parole or temporary absence is granted by a correctional official. And once on full parole, the offender must report to a parole officer on a regular basis. So many inmates are actually released after 1/3 of their sentence, depending on their behavior and their risk assessment. So it's quite common to see federal and provincial inmates released on full parole after 1/3 of their sentence has been served. Statutory release refers to parole in which the offender is automatically released following 2/3 of their sentence. So statutory release basically means that most offenders, if they have not been released already, will be released after 2/3 of their sentence have been served. So if an offender receives a sentence of 10 years, they're almost guaranteed to be released after 2/3 of that sentence. Now, of course, the exceptions are for those receiving a life sentence or dangerous offenders, high-risk offenders. But given that the vast majority of offenders are not lifers and are not considered dangerous offenders, the vast majority of them are released after 2/3 of their sentence. And again, this can be denied by the parole board, but the vast majority of offenders, including some violent offenders, are released after 2/3 of their sentence. Now, the Correctional Service of Canada may recommend that an offender be denied statutory release if it's determined that the offender is likely to reoffend. Again, this is generally a low probability because, as we said, most offenders are not violent offenders. When speaking of lifers, we're of course talking about individuals who are serving life sentence, and even those serving life sentence are eligible for parole. A life sentence does not necessarily mean that the offender will spend the rest of her life, his or her life, in prison. Rather, it means he or she will be under some type of supervision, either in prison or on parole, for the rest of their life until death, unless a pardon is granted. So the exact time that a lifer must serve before being eligible for parole depends on the offense. So today, the criminal code directs that such offenders are eligible to apply for parole as follows. If one is serving a first-degree murder, then they can only apply for parole after 25 years. For those convicted of a second-degree murder, in which the offender had previously been convicted of another murder or another homicide, the parole eligibility is again 25 years. For other types of second-degree murder, it's generally between 10 and 25 years, and that is usually contingent upon what the sentencing judge has ordered. So if it's second-degree murder and the inmate has not had any previous homicide charges, then generally they can apply for parole at about 10 years. But again, it may be as long as 25 years. It's up to the order of the sentencing judge as to when they can actually apply for parole. And anyone else sentenced to life, anyone else other than first degree or second degree murder, it really is dependent upon the offense, but in general, they're eligible for parole after 7 years. So anyone sentenced to a life in prison can be eligible for parole generally after 7 years. Statutory release, in other words parole, is not available to dangerous offenders. And the National Parole Board, which we'll talk about a little later, will not release a dangerous offender unless the board is satisfied that the community would not be put at risk. If it is a high-risk offender and they have not received a life sentence, then the National Parole Board and a sentencing judge can make sure that a long-term supervision order has been applied to this offender. So in other words, this long-term supervision order is an over and above parole, and that basically means that the offender will be supervised for on average 10 years. So it's similar to someone serving a life sentence in that they're going to be supervised for the rest of their life. A long-term supervision order applies to those who are not serving a life sentence, but are still deemed to be a high-risk offender and therefore are also subject to long-term supervision order. So a long-term supervision order generally doesn't apply to a lifer because they automatically are going to be supervised in the long term. So an LTSO, or a long-term supervision order, generally applies to other high-risk offenders other than those serving a life sentence. And finally, in the previous module, we talked about danger offender status. And this is a status that can be applied by a sentencing judge and even by parole board officials that basically ensure that certain incarcerated individuals are not released from prison, period. So they're never eligible for parole. There is a part of the criminal code called the faint hope clause, which gives lifers and gives those with danger offender status to apply for parole, but it's very rare that they actually get parole. And again, we talked about such incarcerated individuals as Paul Bernardo and Clifford Olson, who have received the danger offender status designation, and it's unlikely that they'll ever be released from prison. Some of the key principles that guide parole and reintegration in Canada. Again, the first and foremost is that really only the most serious offenders should be incarcerated and should be incarcerated for long periods of time. And this philosophy is reflected in the idea of promotion, conditional sentences, but also in parole. Obviously, parole, it's all about releasing an offender before their sentence is completed. And that flows from the whole idea that only the most serious offenders should be incarcerated for the full term of their sentence. Alternative sanctions, again, parole is viewed as an alternative sanction. When possible, actors in the criminal justice system, whether it's a Crown prosecutor, a judge, or correctional or parole officials, should strive to use alternative sanctions, alternatives to prison and incarceration. Obviously, parole is one of those. Parole should help promote the rehabilitation and pro-social behavior of inmates. So the whole purpose of parole is to foster rehabilitation, treatment through reintegration and through treatment and other conditions of parole. And so ultimately, the goal of parole and reintegration is promotion of the pro-social behavior and to guard against any sort of recidivism that may occur on the behavior of the offender. So there's really two overriding concerns with respect to parole, and these are the two overriding concerns that correctional officials and parole officials will take into consideration in determining whether or not an inmate should be paroled. And the first of all is the impact on the offender. So will the offender actually benefit from parole? Will it contribute to their rehabilitation and the promotion of pro-social behavior? And the second, obviously, is the protection of society. So society obviously is a paramount concern when an offender is released into the community. And so when a parole board or correctional official makes a decision as to whether an inmate should be paroled, they look at both the impact on the offender, whether it will help, and also whether or not that offender is at a high risk to reoffend in society. Now, the release of an offender, as we discussed in the previous module, really is something that's planned for as soon as the offender enters the correctional institution. So given the important principle of reintegration in the Canadian criminal justice system, offenders within correctional institutions are planning for their release, planning for applications for parole, planning for reintegration from the very beginning. The staff in correctional institutions participate in the parole process by helping inmates develop a release plan. In provincial and territorial facilities, this function is performed by staff variously called inmate liaison officers, parole coordinators, conditional release coordinators. In federal institutions, case management officers and institutional parole officers prepare release plans and other materials that will be used by parole boards in their deliberations. The release plan contains information about where the prospective parolee will live, his or her employment prospects, and any arrangements for community-based support, such as a residence in a halfway house or a residential drug treatment facility. Release plans must be vetted by a probation or parole officer in the community into which the offender will be released. And a key component of the release plan is the community assessment. So this is a report prepared by the probation or parole officer that evaluates the feasibility of the offender's proposed community plan in terms of the level of supervision required and the availability of community resources. Among the areas examined in the assessment are the proposed residence, education, employment, treatment plans, family and other support networks in the community, the extent to which the offender accepts responsibility for and understands his or her criminal behavior, information supplied by the victim, and any recommended special conditions the parole board may attach to the paroled. Parole board members use the information contained in both the release plan and the community assessment report to determine whether an inmate should be granted a conditional release, and if so, the special conditions that should be attached to the release. Many of the issues or criteria involved in parole are set out in the Corrections and Conditional Release Act, which is a federal act. This governs both corrections in Canada and obviously parole. So the legislation sets out the purpose of conditional release, and which is to maintain a just and peaceful and safe society, generally speaking. It also talks about and lays out criteria for the implementation of parole within Canada, and of course this includes the safe, humane custody and supervision of inmates both within the correctional institution and within the community. and it also emphasizes the importance of rehabilitation and reintegration of offenders in society. It lays out the importance of transparency. In other words, that the parole process should be transparent. It should be transparent to the offender and also to the victim and to the community at large. And this basically means that the National Parole Board and correction officials need to disclose information to the offenders and to victims. And in particular, if the offender is being released, information should be released to the general public. And if parole is denied, then the parole board or correctional official has to justify to the offender why that denial decision has been made. The legislation also lays out some very general factors with respect to determining whether or not an inmate should be released. In other words, it lays out the criteria, some of the criteria that a National Parole Board should follow when determining whether an inmate should be released. Now, these are only very general criteria. Every inmate's case is determined individually and uniquely, and there is really no set of very specific criteria or checklist that parole boards have to look at when releasing offenders into the community on parole. So the Corrections and Conditional Release Act is quite general. It lays out some broad philosophical principles on what parole is to achieve. It emphasizes the importance of transparency, and it also provides some general criteria that parole boards should follow and correctional officials as well when making a decision as to the conditional release of a correctional inmate. The decision to release an inmate into the community is made by the National Parole Board or by the provincial parole boards in Ontario, Quebec, and in BC. So in those three provinces, the governments operate their own parole boards. Outside of Ontario, Quebec, and BC, all parole board decisions are made by the National Parole Board. The National Parole Board is an independent division within Public Safety Canada, and it's also independent of the correctional system. So Correctional Systems Canada and National Parole Board are two separate entities, although they're both under Public Safety Canada, and they both tend to work fairly closely together. National Parole Board members are appointed by the Order in Council, which is Cabinet and Prime Minister in particular, and they serve fixed terms. National Parole Board members are centralized in 5 regional offices, and members within each of those offices will travel to institutions within the region for in-person hearings with federal offender parole applicants, so inmates who are applying for parole. So what usually happens is the parole board will receive an application for parole from a correctional inmate, and that will often be accompanied by their release plan and community assessment. And 2 parole board members will travel to the particular correctional institution or some other location in which a hearing will be held to determine whether or not to grant the parole application. And in some cases, victims of the offender will be notified, and they can prepare statements at the parole board hearing. They can also make submissions. Victim impact statements that have been presented to a sentencing judge may be considered. So following a parole board hearing, obviously the 2 parole board members make a decision as to whether or not parole should be granted, and the conditions under which parole is granted are also be specified. Most parole board members are appointed by the Prime Minister or by Cabinet, and while they don't necessarily have an extensive background in the criminal justice system, they do have some training, and they are provided with what's called risk assessment training in order to develop a strong understanding of whether or not the offender is at a high or low risk of reoffending. And so ultimately, the parole board members are determining A, whether the offender is eligible for parole, whether they are at high risk of reoffending, and B, whether or not the parole board decision will contribute to the rehabilitation of the offender, and ultimately will it contribute to the protection of society. In other words, if the offender is at a high risk of offending, then they won't be released. If they're not at a high risk of offending, and if the general safety of the public is ensured, then the inmate will receive parole. Your textbook is pretty good on describing what's involved in a parole hearing, but when a parole board members make a decision, they have to consider a number of different factors whether or not to grant parole. And some of these factors include the criminal record of the inmate, the offense under which they are currently serving, the time they've already served relative to the severity of the offense, their behavior while incarcerated, the inmate's insight and perceptions of their own behavior, as inmates will make oral testimony often to the parole board members. Has the inmate been involved in treatment and training or rehabilitation programs? Has the offender actually been rehabilitated? Is there a high risk of reoffending in the community? Other factors include the mental and emotional outlook of the inmate. Other personal factors may be taken into consideration. Has there been any previous parole violations, if they have in fact been incarcerated before and have been on parole before? Are there plans for employment and training? So they'll also look at the release plan that's been prepared. And they will also take into consideration whether or not there are objections by the victim or victims and by the community into which the offender is going to be released. So definitely the opinions of victims and community members are taken into consideration. And finally, it's important that the offender has support in the community, and this not only means training and a place to live and employment and rehabilitation and treatment, but it's also, do they have family in the community to support them? Do they have friends in the community to support them? So there's a number of factors taken into consideration, and all of these are amalgamated into a risk assessment that the board members take to determine whether or not the offender is eligible for parole and in fact can actually be released into the community on parole. Now, just because someone has been incarcerated doesn't mean they lose all their rights. As described in previous slides and in previous modules, the rights of inmates have not been completely removed. They have certain rights. This has been guaranteed by the Canadian Charter of Rights, and as far as the parole process is concerned, some of these rights are guaranteed by the 1978 Parole Act. And basically, the most important right in the context of parole is that the offender receives due process, which is a fair and arbitrary hearing. It also means that there's transparency so that information is disclosed to them, in particular information on why a parole application has been denied. And in 1992 legislation, the Corrections and Conditional Release Act, this also guarantees inmates right to an appeal decision, a parole board decision. Obviously, the appeal will follow a denial of parole. And that appeal is based on such issues as whether justice has been served, whether the special needs of the offender has been taken into consideration, whether it was an error based on fact. And this legislation also provides for a federal and provincial review, judicial review of a parole board decision, in particular if parole has been denied. So in this case, the decision would be sent to a provincial judge who will determine whether or not the decision was just, and most importantly, whether due process was followed by the parole board in making the decision. This slide describes a few statistics with respect to parole in Canada. At any one time, the number of individuals who are on parole from a federal sentence is about 8,737, give or take a few. The number of parole board hearings held annually is about 16,000, and the vast majority of these parole board hearings are with respect to federal sentences, so those serving 2 or more years. The rate at which a parolee has been granted, day parole is about 64%. So for those applying for a day parole, about 64% actually receive that day parole. And it's much lower for full parole. So only 23% of those applying for full parole receive their actual parole. Now keep in mind that full parole is 1/3 of their sentence. And so while the rate of full parole is quite low, the rate for statutory parole, so that's two-thirds of their sentence, is quite high. And again, the difference is that statutory parole is basically means that most offenders will be released after serving 2/3 of the sentence. But interestingly enough, a relatively small proportion of offenders actually are successful in applying for parole after 1/3 of their sentence has been served. Now the final statistics are probably the most controversial because there tends to be a view that offenders released from correctional institutions in Canada, in particular federal corrections, are at a high risk of recidivism and high risk of reoffending. And in fact, that's not true at all. Those who are released on day parole, a full 88% do not reoffend while on day parole, so they don't commit any offenses. And those on full parole, so those granted parole in after 1/3 of their sentence, 78.8% do not reoffend. So the rate of success of parolees is quite high. And by rate of success, I mean the rate at which they offend while on parole is quite low. Just to follow up on the issue of recidivism of offenders while on parole, Canadians often hear about parole through the media, typically after a parolee has committed a violent offense. The media loves to focus on the relatively small number of released offenders who commit heinous crimes, and certainly this does occur. However, as indicated in the previous slide, most offenders released from custody under some type of conditional release successfully complete their period of supervision. Of those who do not succeed, only a very small number actually commit a violent offense. Statistics on parole outcomes indicate that the majority of provincial and federal offenders released on parole successfully complete both day parole and full parole. Among lifers, even among lifers, there's a 92% completion rate on parole, and the majority of those who did not succeed on parole generally committed a violation of release conditions. In other words, they didn't commit a crime or especially a violent offense. They simply perhaps maybe drank while they're on parole or went somewhere they were not supposed to. So what this means when we say there's a 92 completion rate is that offenders who have a long-term supervision order or who have, say, a 10-year parole following their sentencing, complete this parole without incident or without offense, committing an offense. Now, the vast majority of those who do get into trouble while on parole usually do so within 12 months. And what's been found is that those who violate their parole order often have mental health problems, and so their violations are very technical in the sense they may not have understood the conditions. So many of the violations are of technical nature. As I mentioned, they may go somewhere they're not supposed to, or drink, or do drugs, or see someone they're not supposed to. So generally, it's not a criminal offense they've committed. It's a technical violation, a violation of the provisions or conditions of their parole that they've violated. And again, recidivism often is based on the type of crime. So those who've committed homicide, generally there's a low chance of recidivism while on parole. While those who've committed a sex offense, the chance of reoffending while on parole is much higher. And so obviously these are factors that are taken into consideration by parole board members when they make a decision about parole. And again, sex offenders, especially those who've refused treatment while incarcerated, are at a very low probability of being released on parole. But again, that's a very general statement, and the decisions by parole board do take into consideration a number of factors and not simply the offense of the offender. We're going to turn our attention now to some of the critiques and criticisms of parole. And it's very easy to criticize parole, especially when the media is so apt to publicize violent offenses by parolees. Many of those who criticize parole believe that community sanctions are too soft. Many feel that if you do the crime, you should do the time. In other words, you should do your full sentence. If you've been sentenced to 10 years, then you should do 10 years. Many people don't understand the concept of parole, and so you've had movements in some American states and even the Canadian Sentencing Commission that has removed parole or recommended getting rid of parole. In Canada, parole is still seen as an integral aspect of the overriding philosophy of reintegration. And so parole, like probation, is something that's critical to justice and reintegration. And the idea that parole and probation and other types of community sanctions for offenders ultimately contributes to the rehabilitation and treatment of offenders, so it not only benefits them, but it benefits society as a whole. We know that some of these critiques are misplaced because we know that recidivism rates among offenders are low. And most importantly, what people tend to forget about parole is that it provides a supervised reintegration of the offender. So if an offender is not released on parole, if say they've served the full 10 years of their sentence that's been levied by a sentencing judge, once they are released after 10 years, they are no longer under the supervision of the correctional system, of the criminal justice system. They are now completely unsupervised. So if you take a sex offender who serves his full 10 years and is then released, there is nothing generally that the criminal justice system can do to supervise them, unless you get an extraordinary dangerous offender status determination. But that's why parole is so important, because not only does it allow the reintegration of a inmate or an offender into the community, but it provides a supervised reintegration. And that's what's key, is that they're still under the authority and the responsibility and the jurisdiction of the criminal justice system of correctional institutions. It's simply they're serving the rest of their sentence in the community, most importantly, under supervision. So the question that we should ask critics is, do you really want to have an offender released into the community after serving their full sentence? And keep in mind that serving time at a penitentiary is not exactly rehabilitative. Do they want this offender to be released with no conditions or no supervision applied? So that's why parole is generally a positive thing, because not only does it contribute to the reintegration and rehabilitation of offenders, but it's done so under supervision. Parole boards have also been subject to criticism, and in particular the National Parole Board. First of all, one of the overarching criticisms is that board members are appointed, and these are basically political patronage positions, so that the Prime Minister can basically appoint a political crony to a parole board simply based on their political affiliations, perhaps may even be as a reward for a donation to the party. So this is highly controversial, and many feel that these parole board members are not qualified. They don't have the expertise, and many don't. Many don't have any background in the criminal justice system. They're not criminal lawyers, they're not judges. Many are simply lay people, business people, what have you. And their only basis for being appointed was their relationship with the Prime Minister or the governing political party. Other criticisms of the parole system and parole boards in particular is that the legislation that guides parole boards in decision making, in other words, whether to release an inmate into the community, is very general. There's very general criteria for release. There's no onerous, systematic, rigorous risk assessment instruments that parole board members use. It's often very subjective. And so this has been a significant criticism that there has only been very broad guiding principles in the legislation as far as parole board members use for making decisions. Finally, the criticism is that board members are not accountable for their decisions, that they can't be held responsible for these decisions, and which gives them a certain amount of immunity. And because they're not held accountable, the argument is that they may not take their decisions as seriously as they should. We will end this lecture with a general discussion of the principle of reintegration and how parole fits into that. Within the context of parole, reintegration can be defined as all activity and programming conducted to prepare an offender to return safely to the community as a law-abiding citizen. So like parole, reintegration is a process rather than an event. For offenders, it begins with the institutional treatment program, if they're in fact in a program. It continues with the development of a release plan that sets out where the inmate will live, work, or attend school, and if required, participate in a post-release treatment program. So the whole goal of reintegration, again, is to avoid recidivism, and ultimately it is to rehabilitate offender, if I can use that old term, rehabilitation, but to promote the pro-social behavior of offenders and to reintegrate them back into society where they're productive, law-abiding members of society. So parole, like probation, like the conditional sentence a judge may hand out, is all part and parcel of the broad principle of reintegration. And again, as we've emphasized throughout this course, reintegration is a fundamental aspect of the Canadian criminal justice system. And again, it's often misunderstood. It's often seen as simply coddling of criminals, releasing them back into the community earlier, giving them probation to begin with. But again, it's seen as the best way to protect society from reoffending, because reintegration is seen as the best way to promote law-abiding, pro-social behavior of offenders, and more specifically to reduce recidivism.